Here for our Diversion Reentry Workgroup meeting. Today, May 13th, 2022. My name is Brenda Graylish, and I'm the Executive Officer of the Council on Criminal Justice and Behavioral Health. I'm very excited to have everybody today. For those of you who attended our earlier Juvenile Justice Workgroup meeting and are continuing on, glad to have you stay with us. And for those of you who are new with us today, welcome and thanks for spending your time and your afternoon with us. We'll go ahead and I'll do a quick introduction of our council member advisors. I'll ask Chief Jenkins to introduce himself, followed by Judge Manley.
Thanks, Brenda. Mac Jenkins, a retired Chief Probation Officer and a co-advisor to this work group.
I'm Stephen Manley, Superior Court Judge from Santa Clara County, and I'm also a member of the council and an advisor.
Great. Thanks, Judge and Chief Jenkins. And we also have, I'll just make a notable mention of Director Tony Hobson, who's here with us today. Wasn't able to join us in person, but here as a participant listening in on the discussion, since we weren't able to notice that by the Bagley-Keene specifications or guidelines or timelines. But thank you so much, Director Hobson, for continuing to listen in and track the discussion. So moving along to the next slide, we'll do a little housekeeping. I want to let everybody know that the work group is being recorded. When we get to the question and answer portions of our presentations, we ask that you use the raise hand feature to make a comment. Once you raise your hand, you'll be placed in line to comment and be asked to comment in the order in which the requests were received by the host. When it's your turn to comment, our meeting host will, actually you can unmute your own line in this particular platform with Microsoft Teams. You'll be able to unmute your line and announce your name and make your comment, which we ask that you keep to 3 minutes or less, just to make sure that we have everybody's, have enough time to get through the presentation and the material today. We also, for folks who are here in person, which we actually don't have folks who are here in person at this point in time, but if they do, we do have a podium here where folks can make comments. As always, if you think of something later or just want to share information with us, we have our CCJBH email account, ccjbh@cdcr.ca.gov, and we always welcome and love hearing from our participants. Next slide, please. Just a little bit on our webinar policies for participation. We certainly welcome your participation throughout this meeting, but please note that disruptive behavior is not aligned with the purpose of this session and won't be tolerated. If any individuals disrupt the meeting, you might be removed without warning. In the event of a security incident, our session will end immediately and will not resume, but we will send a separate email to all participants with further instructions. And for question and answers, which we do also want to encourage, we do ask that participant comments in the Q&A, or we want to mention that the Q&A does not reflect the views or policies of the presenters, CCJBH, CDCR, or affiliates or contractors, and that by using the Q&A, you agree to keep your comments relevant to the topic of today's event. And while a variety of diverse perspectives and opinions is welcome, disruptive comments, again, are not aligned with the purpose of this meeting, and users creating disruption also in this event may be removed without warning. So with that housekeeping out of the way, next slide, please. I'll go over the agenda. So we did our welcome and introductions. We'll give an update on our technical assistance, our diversion technical assistance contract. That's the contract that we have with the Council and State Governments Justice Center. And that will be followed by really what we're excited to have a robust discussion today on Senate Bill 317. We'll have showing a background, discussing the background and implementation of SB 317. This is a topic that our numerous council members had asked to discuss, so we were wanted to certainly carve out time during one of our work group meetings to do that, and so happy to have that on our agenda today. And that will be followed with another Q&A with our council member advisors, public discussion, and then we have a few announcements at the end. And we will adjourn no later than 5 o'clock. So with that, we will hop right in, and I will give a update on our diversion technical assistance contract. Next slide, please. So we began our contract with the Council on State Governments Justice Center last July 1st, I believe, and really focused on diversion, consultation and technical assistance to expand or sustain local capacity. And Council on State Governments Justice Center has been moving through this project by hosting a variety of learning communities, listening sessions, and we'll be having topical work-through sessions, really either providing technical assistance to counties who volunteered to participate, who are either implementing diversion right now in their counties or interested in implementing diversion. And all of this information, either that's been heard through these learning communities and listening sessions and topical work-through sessions. All this information that the Council on State Governments Justice Center is gathering will be compiled into a final report that includes recommendations to expand mental health diversion in California. And we're anticipating that report from the CSG Justice Center in December 2022. I think that's it. Next slide. Is there another slide? Nope, that's it. Okay. So with that, we'll open it up if there's any questions or comments from our council member advisors on the CSG diversion training and technical assistant and consultation contract. Okay, seeing none from council. Oh, did you have any, Judge? Did you want to?
No, I would just state that I did participate in one of their presentations, and I thought it was excellent and well attended.
Great. Thank you, Judge. Appreciate you sharing that reflection. And any public comment on our contract with the Council on State Governments Justice Center? Any of these updates? Okay. Let me put my chat on. Not seeing any. Next slide, please. Okay, well, very excited for the meat and potatoes of today's discussion on SB 317 for the background and implementation. And we have a variety of panelists today, so I will list off who our panelists are, the representation that we have for today's discussion. Each panelist is going to give a brief presentation, about 7 to 15 minutes, depending on who's presenting. Some might have a little bit more. And we've already discussed that with our presenters. And so we'll have each presenter give a little bit of their perspective, provide their perspective on SB 317, the background and implementation. And after each presenter, after we move through all presenters, then we will open it up for a discussion with our council member advisors and then off into with our participants, anyone else who's joining us today. So our panelists today, we have Laura Arnold, who's the lead attorney in Writs and Appeals Unit from Riverside County Public Defender's Office. We have Henry Bratton, Program Manager at the Office of Diversion and Reentry in Los Angeles County. We have Katie Herman, who's a Senior Policy Analyst in Behavioral Health with the Council on State Governments Justice Center. We also have in the room with us today, Deanna Adams, Senior Analyst, Criminal Justice Services at the Judicial Council of California. We have Dr. Oglesby, Deputy Director of Forensic Services in San Bernardino County. So with that, I won't talk too much more, and I think I will turn it over to Ms. Arnold to set us off and give us a nice foundation on SB 317 and kind of kick our discussion off. So welcome to all our presenters, and welcome, Ms. Arnold.
Thank you so much, Paige. And I just wanted to clarify, I don't work for Riverside County anymore. I actually am the lead attorney in the post-conviction unit for Santa Barbara County Public Defender's Office. And I think my office would probably want me to set that straight. So I'm doing that.
Thank you so much, Laura. And I just realized my agenda was the old one. So I see that on this slide now, we did catch it in and got it into the slide. So thank you for making that correction.
No worries. And it was at one point accurate. So there's that. So good morning or good afternoon, everybody. Happy Friday. I want to just talk really briefly about SB 317, why it needed to happen and kind of what it is. And then maybe talk just a little bit with you about some of the challenges I think we're all facing in implementation. So can we go to the next slide? So prior to January 1st of 2022, I think everybody here knows that we did 1370.01, which is a statute that mandated restoration treatment when a person charged with a misdemeanor offense only was found to be incompetent to stand trial. And that person could be held in a secure setting for only as long as 1 year or the most serious punishment for any crime charge. Sometimes that was 6 months, sometimes that was 90 days. And that was the total amount of time that anyone had to work with the individual before the case had to be dismissed and they had to be released. The restoration treatment was often given in the jail because of lack of placement, outpatient treatment opportunities. And the treatment was really focused on getting the individual to a point where they could rationally cooperate with their attorney, where they understand the roles of the players in the court, where they understood what a plea of guilty meant and what a plea of not guilty meant and what a plea of no contest meant. And as it was often the case, by the time we got to that maximum date by which they had to be released, they hadn't been restored to competency. Their mental illness had not really been treated. Their symptoms were not really in full remission, and they would be released to the streets, often with nothing but a prescription for a 7-day supply of medications that they didn't have the wherewithal to fill. And so for this population, this really became a revolving door of arrest, incarceration, mandated treatment geared toward restoration, release, rearrest, sometimes within 24 hours, sometimes the same day, etc., over and over and over again. And so they weren't getting well. They weren't getting better. They weren't getting any kind of long-term treatment. And we were feeling like all of this money was being thrown at this in a way that didn't make sense, given what we know about the population, that they are overwhelmingly unsheltered homeless, that vast majority of the crimes charged were nuisance offenses or status offenses, things that just go along with being homeless and being always under the radar of law enforcement and being acutely psychotic and behaving in a way that gets you brought to the attention of law enforcement. We saw a lot of them being taken to and rejected from emergency rooms, being taken to and rejected from 5150 holds, and sometimes just straight to jail. And we all know who the people are because they're the people that come back over and over and over again. And so SB 317 was created to do something different with that group of people, because using jails as a treatment center for them was not working. Now, effective January 1st, 2022, we no longer have any mandatory competency restoration authority with regard to people who are in the criminal justice system solely based on misdemeanor charges. So no longer are we worried about teaching them the 7 pleas and telling them the role of their lawyer and getting them to the point where they can enter a guilty plea and be released with credit for time served on summary probation for 1 year, which is good because that wasn't really doing anybody any favors. So now the goal is to direct these folks as quickly as possible to the appropriate level of care. I think that, in Santa Barbara County, our CEO's office used the word Delta, which was new to me because I'm not a visual learner. But yes, the idea is that if at all possible, we want to divert as many of these folks as possible and engage them, involve them in consensual voluntary treatment rather than involuntary treatment, which, as you know, is the most expensive kind of treatment, not necessarily the most effective treatment, and the most controversial type of treatment, particularly when you're thinking about civil liberties. So now, upon finding that a defendant is incompetent to stand trial, the court must consider them for mental health diversion. And some of them very few of them may be statutorily ineligible. Honestly, most of the statutory disqualifiers deal with felony offenses, not misdemeanors. So very, very few of them will be statutorily ineligible. But most of them will be eligible. And the only question will be, is there a treatment program in the community that will consent to treat them? And will they agree to do treatment? If they're found eligible for diversion, they must be granted diversion. If they're not found eligible for diversion, or if they don't succeed on diversion, and by that I don't mean one relapse or one failure to comply with treatment, or, you know, we all know that this is a long road and that we have to just continue to meet these folks where they're at. So if they really truly cannot succeed on diversion, then the court has very limited options, and the timeframes for those options are intentionally short. The court can either refer to behavioral health for possible AOT if the county has services under that section. The court can refer for LPS if, based on an opinion of a qualified expert, the person meets the statutory requirements for grave disability, or the court can dismiss the charges in order that the defendant is released. I think that it's clear from the statute that the goal is not to get to those methods of last resort unless we absolutely have to do that. And so I think that the challenge that we all are facing is, how do we identify this group of people at the earliest possible stage? How do we, when they are acutely ill and unmedicated and potentially on controlled substances, how do we begin the process as soon as possible of trying to engage them and trying to get them to trust us and be willing to do something that's incredibly uncomfortable and for them, and which feels incredibly unsafe for them? How do we entreat them with something concrete rather than the conceptual promise of a dismissal at the end of 2 years or the end of a year, when they're still very much symptomatic and really they can't grasp what we're talking about? How do we use things that we know appeal to them? How do we motivate them and incentivize them? And then how do we help them succeed? And so we get back to where we all always get back to, which is housing first, right? And there's no such thing as one size fits all housing, and it's a very difficult population to house. As one of my favorite public guardians ever, Deborah Buckles from Stanislaus County, used to say, they can't live alone and they can't live with other people. So it's a real challenge to find safe and suitable and appropriate housing that is appealing to them enough that they'll agree to try something new or to retry something new or trust us when they've learned to distrust us. So we can go to the next slide, which is the process flow. Just kind of gives you, for those visual learners, and I think this really shows you that I'm not a visual person, because I can do better with smart art than I did here, but this is pretty much how it goes. A person shows up in court and there's a doubt as to their competency to stand trial. From a public defender perspective, it means we can't communicate with them. It truly does. And I don't know how to put it in any other way. It means that they're so ill, and we may not know why, but we've been doing this a long time, and we know that they can't hear us, and that they're not just not listening, but they can't hear us. They can't accept legal advice. They can't engage in a conversation that's rational. And so we'll declare a doubt. And then there's this period of time, which is kind of our optimal period, where if we can get them engaged in treatment, if we can get them to a therapeutic setting, if we can get them excited about just the prospect of a concrete reward tomorrow or today, if they talk to us, if they take their medication, if they follow the rules, maybe we'll never get to a point where they're found incompetent to stand trial, at which point we have to go all of these involuntary paths. But if we don't do that, we know from experience that what's going to happen is they're not going to ask for psychiatric treatment in jail. Unless they're danger to self or others, there's not going to be any psychiatric treatment in jail. And what's going to happen is they're going to get sicker, they're going to get worse. And by the time they're seen by an alienist to assess their competency, they are going to be found incompetent. And if we aren't ready, they're going to be released to the streets very quickly without any treatment. So that's kind of the way that, at least in Santa Barbara County, we've approached it. largely with the inspiration of our Chief Probation Officer, Tanya Heitman. We have realized that having the prospect of supervised OR release gives our clients an opportunity to choose treatment over jail. And it also gives the court some oversight and some ability to respond quickly if the setting that they're placed in is not safe for them or is not safe for other people. And it allows reporting to come back, and it allows behavioral health to work with them outside of the jail in a safe and therapeutic setting, in hopes of getting them to a point where they can voluntarily consent to diversion as a competent person can. So I don't think that was even close to 15 minutes, but I could sit here and tell you all of the challenges that I see everybody facing in the state, but you're living them, so you don't really need to hear that from me. I think the only thing that I would add from my perspective, and this is not my perspective, this comes from having dinner with people that know a lot more about this than me, and kind of being in this space for the past 6 years, very immersed in this space and seeing what's happened and why it maybe isn't working. I think that a lot of what we had to create in our local county behavioral health systems was responsive to legislation and funding sources. I think that a lot of it was limited in terms of identifying populations that the funding can go to and excluding other populations. And those populations could be based on level of care. It could be based on current criminal charges. It could be based on past criminal history. And we just keep building new things for different populations, but we are using the same base of resources to do it. And that base of resources has gotten really thin and very, very extended. And it might be time for us to kind of separate from those buckets and look at the true continuum of care in our respective counties and stop worrying about the MOU that says that someone charged with this crime can't have this kind of treatment. I think that we only have so much to work with in terms of resources, and it gets too messy and too non-evidence-based when we are forced within the confines of an adversarial criminal justice system to build consensus and to come up with exclusionary criteria that don't really relate to the treatment needs of the individuals in our counties. So maybe that rings true to some of you. Maybe I just declared war. I don't know. But that's really all that I have to say. And
Great.
so.
Well, thank you, Ms. Arnold. Appreciate you kind of setting that foundation for us, kind of teeing up this discussion. So we'll move next to Mr. Henry Bratton, Program Manager at the Office of Diversion and Reentry in Los Angeles, to give like lived experience perspectives and a little bit about what LA County is doing. Mr. Bratton?
Hello, everyone. First up, excuse me. Yes, my name is Henry Bratton, and I would like to let you know that I have lived experience. I'm an ex-life-term prisoner. I spent 36 years in the state of California's prisons. I've been home 12 years. During these 12 years, I was a alcohol and drug counselor for 2 years. I was a bridge housing specialist at the VA. I worked as a CHW for the Whole Person's Care Program at AMNI, and now I'm a program manager with ODR. I'm really not that expertise on 317, but it's kind of like common sense. I entered prison at 18, so you know I was a waiver, could have been juvenile or whatever, but it's a tricky cutting hair when you define people with like mental health issues, and we try to like put everybody together. Like I didn't have one, a documented one. Was I a social deviant? Yeah, my deviant behavior put me in prison. But when we talk about the juveniles, I'm assuming it's the very young up to the 25. Does it go all the way to 25 or 26? Anybody? It does? Okay. So you can't group all them together, because you can't group the real young ones together with the real old ones, because then you're going to have some issues where people are going to take advantage of each other. The program that the young lady was talking about earlier about the diversion part, we have that diversion part for the adults. And when I first started at Amity, I worked in that program for like 2 months. And it was kind of unusual for me being on the other side of the fence, talking to the judge and the DA and everything, but I was okay because we weren't sending anybody back to prison. So we were trying to divert. And their program consisted of making sure that you were housed, but these are adults. So they can have a lot more latitude where they house people that are adults. Now we're talking about juveniles. Juveniles, you're going to have to be a little bit more, not too boxed in, but they're going to have to be in areas and places where they're comfortable. Because the first thing that you can't do, you can't make these individuals feel uncomfortable and like they're in prison, confined, or anything like that. And that's real hard to do. And when you're young, it's especially hard, because of young people, we have a tendency to rebel. So when you start trying to house, start trying to house juveniles, you can't put them in the in a situation where they're all grouped together and they're just running around like the Bowery Boys. I apologize if I went back too far. That dates my age, but you really can't. There has to be it has to be, it has to be some TLC with the kids. It has to be, you have to show them some love. They're going to always respect authority, but you can't be authoritative person in the sense of like putting jail confinement over their heads. But the 317 in itself is a great idea. It just reminds me of how it was for I guess adults back when I first got incarcerated, because what you guys are reiterating is the same thing they used to have for adults that you want to do now for juveniles, which is great, because you want to get it before it starts. You want to get at the individual before it starts, to where they don't end up in the house that there may be no return to.
Mr.
So
Bratton, I'm sorry to interrupt. I was just saying, do you have some perspectives, given what Ms. Arnold was talking about with, the changes of what used to be called misdemeanor incompetent to stand trial, and how now that has changed, where individuals can then, now be diverted into programs, and kind of what LA County is doing, what your program's doing to help connect folks with treatment in your...
yes, sure. We have the diversion program for the adults, and we've just launched one or two. I think it's two for the youth, for the juveniles. We literally just launched them, and go ahead.
Oh, I was just going to say, I think the focus of this is for more adults, for the adults. I mean, it could be the age span of, 18 and above, but probably the most individuals that'll SB 317 will apply to is adults. So
Right.
I know there's
So
transition aged youth in there, but yes.
right, but the programs are they're almost mirror each other in terms of what they do. It's so when in LA, like we haven't really taken off with the youth with the youth yet, because we've just begun, but the programs they mirror the adults program. However, you can't treat it the same. You can't treat it the same as the adults, but it's like it's a fine line when you deal with younger people. Younger people, they're going to be rebellious. They're going to be a little stubborn in their ways. the high acuity ones with the serious mental health issues, they're going to be more of a challenge. We've had the same things with the adults. So everything is still pretty much the same. It's just how we're going to treat the youth. And you can't treat them like babies, and you can't treat them like adults. You got to meet them where they're at. You have to meet these individuals where they're at. A lot of people, that's what we do. That's what with our reentry programs, we meet all of our clients where they're at. And you can't box all these young people in. You have to meet them, each individual ones where they're at, and guide them through. It's going to be real tricky. You're going to have some younger people in the profession to deal with them. You don't want to look too authoritative for them, where they already formulated that you're the police, you're authority, you're against them or whatever. You're gonna have to have a younger generation of a workforce that's really serious about helping those clients.
Great. Well, thank you so much, Mr. Bratton. Appreciate your perspectives. So I think next we will turn it over to Ms. Katie Herman, Senior Policy Analyst in Behavioral Health at the Council on State Government's Justice Center.
Thank you. Can you hear me?
You sure can.
Okay, great. So yes, I'm Katie Herman. I'm a Senior Policy Analyst here at the CSG Justice Center. I live in San Francisco now. I've been here about a little more than 2 years. I'm a social worker by training, and before joining the Justice Center, I worked in New York City for a large agency that did a lot of alternative to incarceration work, primarily for people with serious mental illness. I worked on our Alternative to Incarceration Act team, where the majority of our clients had been involved in the competency system. And when I was in New York State also changed their misdemeanor competency process and legislation. So I have that context sort of in my mind as I talk about this as well. So next slide, please. This is just a brief summary of what the Justice Center is, for those of you who aren't familiar. Next slide. And as Brenda mentioned earlier in the meeting, we are working with CCJBH on this diversion project to help counties improve and sustain and just work towards developing like model diversion programs throughout the state. This slide, we also work with the Department of State Hospitals on their diversion training and technical assistance work, and there's some overlap, of course, but this is just a list of all the different activities we're doing as part of our work with CCJBH. As Brenda mentioned, we just finished our learning community around diversion yesterday, which I'll talk about a bit more. We administered a statewide survey about diversion. We have we've been doing virtual regional listening sessions with people with lived experience of diversion, their family members, and other stakeholders. We have some upcoming topical work through sessions. And then, as Brenda mentioned, we're going to write a final report about the challenges, policy issues and recommendations, lessons learned, et cetera, at the end of this year. Next slide, please. So this is a list of the counties who were participating in our diversion learning community. As you'll see, it's a really nice mix of large urban counties, some more suburban counties, more rural counties. So it's been really great to have such a diverse mix. And we've really talked through kind of the path of a case through diversion in the learning community, from the how to identify appropriate candidates, how the referral process goes, how the evaluation process, the treatment process, the treatment planning process, the court monitoring piece, and then we had a separate session just for judges. So it was really successful. As I mentioned, it finished yesterday. And in one of our sessions, much like this group, people were really interested in talking about SB 317. Again, the challenges and recommendations. A lot of this is very similar to what Laura spoke about. But this was the group of counties that we discussed this new legislation with. So on the next slide, again, a lot of this is very similar to what Laura mentioned and what some of our other speakers will probably talk about as well. But, a lot, and I should mention that the learning community, each county had an interdisciplinary team of a judge, district attorney, public or defense attorney, and then a behavioral health provider or administrator. And a few teams also had a court administrator, a court coordinator. Some of the challenges that we discussed during these sessions were around, the very short time frames for, coming to some kind of disposition when someone is found incompetent on a misdemeanor. The challenges and sometimes just inability to compel people to take medication in jails. So it's very hard to stabilize people if they're unwilling to take medication, and it's hard to, as Laura mentioned, communicate with people and discuss their options when they're very symptomatic and not willing or able to take medication. And along those lines, of course, it can be difficult to get treatment buy-in from participants who are, again, very psychiatrically unstable, who may have limited insight. People talk about if the option is, okay, you can do, if it's presented as you can do this diversion program and be under court supervision, or your case will probably end up getting dismissed at some point down the road. It seems like oftentimes people will make that decision because it's just less burdens on them. Also just have many, it seems like all counties just feel like they have a lack of, locked inpatient transitional facilities where someone could be, transferred from a jail to some kind of transitional facility to stabilize and then be released, once their case is dismissed. Very few counties have a system like that that has enough bandwidth to work with the number of people that are being found incompetent on misdemeanors. Conservatorship is one of the options for a case, and just many of the participants in our learning community discussed their county's overburdened conservatorship system and just, very long waits and delays in getting people evaluated for conservators, and also the high threshold to be eligible for a conservatorship. So people kind of get stuck in this holding, waiting pattern. Also along all these lines, just insufficient jail discharge planning and warm, I like the term hot handoffs from jail to the community. So people are, as Laura mentioned, just being kind of released if they're not participating in diversion onto the streets with really no connection to treatment or case management. So that's definitely a big challenge. And then some counties had tried to develop some kind of system where someone who was found incompetent their case gets dismissed, they're being discharged from jail, and they're able to get them into a hospital to be evaluated for admission. But so often people don't meet criteria for, they're not considered to be a danger to themselves or others, and they're immediately released from the hospital. Next slide, please. So we also talked a bit about, recommendations for how to address some of these issues. The number one recommendation, which isn't on this list, I think, of course, is, a lot more crisis services, pre-arrest diversion, so that people ideally aren't getting arrested to begin with on especially, low-level misdemeanors, so that they don't have to enter the system to begin with. That's a different discussion, but, that's one very key recommendation, is to stop people from getting into the system to begin with. But some other recommendations that came out, and I'll add some more that aren't on this list actually, but more funding and resources for conservatorship, the conservatorship system in counties that are very overburdened, because for those people that do meet criteria and really need conservators, they should be able to access them quickly and easily. Some other recommendations, especially from some of the judges who participated, were legislative changes to the statute to extend the time frame so that people of course, we don't want to hold people in jail longer, but just a little more time to come to some kind of plan and disposition for people's cases so it doesn't feel incredibly rushed. Increase opportunities for jail in-reach and warm handoffs to treatment as much as possible. Additional training and resources for defense attorneys, but I would say for all court staff and behavioral health staff around motivational interviewing and engagement, especially for people that are very psychiatrically unstable. And also, some kind of streamlined 5150 process from the jail to a hospital for inpatient evaluation. So at least getting people to the hospital so they can be evaluated in some kind of streamlined way. A few other recommendations, again, as Laura really mentioned, is, offering really concrete incentives for people, the use of peers and peer specialists in that space, I think would be really helpful to have someone like us, a peer specialist assigned to every person who is found accompetent on a misdemeanor to really help them with that jail in-reach, that engagement, that developing a rapport. It's not necessarily, ideally someone would engage in treatment voluntarily, but often it's, those case management needs that are much more urgent and like appreciated by the participants than like traditional treatment. It's a good way to kind of get someone into treatment is to first offer like case management supports. This is kind of on a different track, but also, perhaps more outpatient restoration services. That would, of course, we would need to change the statute. And not that we want to keep people in the criminal justice system longer, but that could be one option. It's not jail, it's not the state hospital for restoration. And yeah, as I just mentioned, I really think also, as Laura talked about, just that key is engagement, offering concrete services, housing, assistance with benefits, food, clothes, to help people connect to some services, even if it's not necessarily immediately like treatment, can be really beneficial for this population. So that was the end of my slides. I had just had one more slide with my contact information and our more resources with the Justice Center. And yeah, I'm looking forward to hearing from the rest of our speakers and answering any questions or providing other feedback.
Great, thank you so much for sharing that. So we will move next to Deanna Adams, who is here with us in person, Senior Analyst for Criminal Justice Services for the Judicial Council of California. Welcome, Deanna.
Hi, everyone. It's so interesting and also kind of weird being back and being in this Board of Parole hearing room. It's, it's been 2 years, but time has flown by, so I'm glad to be back here in person. And I know I have the mask on, so hopefully I'm not too muffled for those of you who are tuning in through Teams. My name is Deanna Adams, and as Brenda mentioned, I'm a Senior Analyst with Criminal Justice Services for the Judicial Council. My work focuses on the intersection of the adult criminal court system and mental illness, and some of the other roles within my duties at the Judicial Council is looking at things such as diversion, collaborative justice courts, and other policy and court processes that impact these vulnerable populations who are moving through the adult criminal court system. I will say I'm very happy to be sort of centered in the middle of these conversations. I, can just look to Ms. Arnold and thank her for going through, the impetus behind SB 317 and the process. One of the things in just putting together my slides is what to focus on in limited time. So thank you so much, Ms. Arnold, for that. And thank you, Mr. Bratton, for focusing on the need to individualize how courts and how different providers who are working with the courts for people who are impacted by 317 are being held in ways that it's speaking to their needs. And then also thank you to Ms. Herman for introducing many of the challenges, some of which I will probably not spend too much time on because you did cover some, but you definitely touched on some things that will go to what I'm touching on today. Next slide, please. So in looking at what I can cover in about 7 minutes, I wanted to focus on 3 different perspectives. So 2 will be looking at the different 2 of the different pathways that SB 317 opened up. And then 1 just going back to the broader IST and the need to look at SB 317 with all the other sort of state conversations that are looking at IST broadly. So next slide, please. I do want to mention that, as many of you know, the courts, there are 58 different courts, so 58 different court processes. What I'm going to mention today may not necessarily apply to every court, particularly as there are different concerns, different local partnerships, again, 58 different partnerships. So it may not speak to all courts, but it will look at some of the challenges that courts have raised to date, as well as some of the just considerations that people are looking at as we are all wondering how SB 317 will be implemented and how it'll move forward. I would say one of the things that has come up time and time again is the need for, the courts really want to implement this in a way that it's responsive to everyone's need and that it's providing the best possible legal, health, and justice outcomes for people. So how can, with the different timelines, as Ms. Herman mentioned, and the different, some of the different barriers and what's available in the counties that both Ms. Herman and Ms. Arnold mentioned, how can the courts really do this in a way that is efficient, getting people where they need to be in a way that they are not going to end up back in this process over again? Can you please go to the next slide? And also, speaking with the mask on makes you very thirsty. Pardon me for a second. So moving to diversion, and next slide, please. So one of the things that the courts are looking at is how people from SB 317 are going to be connected to the mental health diversion, especially as courts are, we're just 2 years into the implementation of mental health diversion. So as you may want to squint your eyes to focus on the numbers, I will tell you there is nothing telling about the data and 317 at the moment. But as you can see over time for, when AB 1810 was implemented. I'm going to take my mask off. I'm sorry, I cannot talk with this on. Yeah.
Whatever's comfortable.
As courts have begun implementing AB 1810, we have been noticing just the trends and also challenges that courts have in really figuring out how to connect people to medically appropriate treatment, as well as culturally responsive treatment, as well as some of the just coordination barriers that need to be solved individually within each county to make sure everything is being implemented effectively. With the coronavirus, sorry, my mask really made my mouth dry.
No worries, Deanna. Do what you do.
Didn't think that through before coming here in person, so I do apologize for those interruptions. So as courts, we're dealing with COVID and the pandemic responses that have impacted the initial implementation of mental health diversion. Now courts are thinking how they can take lessons learned during that time period and really move into a process that will help people who are being diverted through SB 17 benefit from what's been learned, but also understand what unique challenges may come out of it with, with this new process sort of moving into the court processes. Also, courts are looking at, sorry, this mask really dried my mouth out. So courts are also looking at how mental health diversion is going to be filtered within the actual court process. So, with mental health diversion, there was a petition process. With SB 317, it's moving through a different process. So how courts are able to keep up with that. Next slide, please. Next, I'm going to focus on AOT, assisted outpatient treatment. As Katie mentioned, we've been hearing from courts as well, how they can make use of that existing statute to impact people who are moving through that process. Next slide, please. as well as how courts that are in counties that are fairly new to implementing AOT, how they are able to get the process up and moving in light of that. So as some of you may know, AB 1976 was required courts to begin implementing AOT by July 1st of last year, and for the counties that are unable to at this time to formally opt out. So there are a lot of new courts that are in counties that are now offering AOT. So a lot of look at how courts are able to look at, get AOT operationalized for people who are not moving through SB 317 while simultaneously working with those who are going to be sort of moved into that process at this time. Next slide. And knowing that I took a lot of time just trying to be able to speak, I will just move really quickly and move to our next slide, please. To talk about the need to look at SB 317 in light of all the other conversations that are happening. So as many of you may have known, last year there was the felony IST conversations that were held by Cal HHS and the Department of State Hospitals that look broadly at the wait list that DSH is focusing on. And during those conversations, there was a lot of talk about how courts and how counties generally are getting people connected to services and medication while they're being held in jail going through the IST process. There's also concerns about that were mentioned about maintaining a sufficient pool of evaluators that the courts can call on to have people evaluated. And that's something that isn't strictly a felony IST issue. That is something that expands beyond felony IST to the overall IST population. So as CCJBH, as you're looking at legislative priorities, I would strongly recommend revisiting some of those conversations from that process, because a lot of the things that it was myself, a few other people from the Judicial Council, as well as Judge Manley, highlighted different opportunities that really needs to be addressed. And although it was focused on the felony population, those were issues that also impacted people who are moving through the IST process regardless of their felony or their charge level. Next slide, click once, all right. Also, as we're having conversations like this today with SB 317, we are looking, obviously at the people who are impacted by this new process. But that, again, doesn't change that there are processes that come a little bit before 317 is triggered. So looking at, while we're focusing on those, we need to look at what comes before as well as what comes afterwards. Next. So just bring it all, we'll look at, as we're looking at these different populations, looking at different challenges and different exit points and other opportunities to really target people and work with people, looking at everything as a whole, because once we put everything together as a whole, we can, see the challenges that are universal across felony and misdemeanors, as well as identify other opportunities that, without looking at it as a whole, we are not necessarily tackling the full issue. So just being mindful of that. And next slide. So that is all for me today, and I'm going to put the mask on and drink lots of water after this. Thank you all so much for your patience.
Thank you so much, Ms. That was a lot of information to cover. Yep. Okay, and last but certainly not least, we have Dr. Oglesby here, Deputy Director of Forensic Services for San Bernardino County.
Good afternoon, everyone, and thank you for allowing me to participate. My name is Bill Oglesby. As Brenda said, I work with San Bernardino Department of Behavioral Health, specifically in forensic services. Our division oversees both adult and juvenile services. Prior to coming to San Bernardino, I spent 5 years with CDCR in a variety of roles, from line psychologist all the way up to hospital administrator. Prior to that, I was with the Florida Department of Corrections and associated and varied vendors providing services to that population. Before I talk a little bit about my presentation, I wanted to hit on some of the things that my colleagues have already hit on. Laura, you indicated that, in your opinion, there's a hodgepodge approach to diversion. Yeah, I agree with you 100%. In fact, later on, Deanna, you mentioned that there are 58 different courts with 58 different processes. Agreed 100%. So to the notion that resources and money and funding notwithstanding, that standardization is required, I agree wholeheartedly. Henry, you spoke quite a bit and passionately about the juvenile population. You know, the best way to make use of AB 317 or SB 317, take care of the youth first. If you provide
Sure.
appropriate services to juvenile offenders, SB 317 becomes moot. And then last, Katie, we were one of the participants in the Learning Collaborative, and again, I can't state this enough. It was fantastic to have the opportunity to sit in. Any gold standard approaches that we can take, that we can standardize, will make life a lot easier for this population. I'm going to talk very briefly about our experience of diversion pre and post SB 317. Broadly, we had two populations that we would divert. We would have felony ISTs that we could divert, and those who fell under the criteria of 1001.36. The felony IST population, we would treat under our DSH diversion demonstration project. Several counties have this, so we are able to serve those who are felony IST or likely to be found felony IST. Our other program provides general mental health diversion, as I said, under 1001.36. So before SB 317, we would send a team out to complete an eligibility assessment, provide a service recommendation if that defendant met our criteria. And we would have that returned to the court within 14 calendar days. So that means that we would send teams into the jail or into the community, wherever the defendant might be located. And then some of our service recommendations would be anything from, let's say the defendant was already receiving services from a DBH clinic or a managed care clinic. We might recommend that they continue treatment there. We might refer them to our general diversion program. We might refer them for SUD services as well. Our program staff, when diversion is granted and a defendant is linked to a DBH program here in the county, our outreach staff or our in-reach staff, we call them RISEs, would make sure that that defendant had a supply of medication prior to release. Ideally, a 2-month supply or a 3-month supply, but a 30-day supply. Our in-reach team for those defendants granted diversion would work to move heaven and earth to identify housing, which in San Bernardino County is predominantly shelter housing, emergency shelter housing, and then would attempt to coordinate transportation. Again, pre-317, for missed defendants, those folks would not be referred to our local CONREP, but they would be referred to our conservatorship unit for determination of placement, whether community or DSH. Prior to 317, the majority of those assessments would be referred to DSH. 317 comes along. What's new? Well, not a whole lot in terms of process, but there are some caveats. The 14-day evaluation period that we have to review and evaluate for eligibility for diversion is difficult to meet. So instead of taking them as they came, we now evaluate defendants based on their court dates. On the plus side, we had anticipated a deluge of missed referrals, or those who would formerly be called mists. And we have not seen that. Our conservatorship unit is extraordinarily happy about that because, as with so many other counties, conservatorship units and evaluators and programs are overwhelmed. This is because a great many of these cases are dismissed outright. During my time in Florida, I provided competency evaluation and NGRI evaluations to 2 of the court districts. I think in all the IST evaluations I ever completed, I only ever saw one misdemeanant. And so when I came here, I thought, why are we having mists? What's going on here? So I'm glad to see that. It's just not worth the effort to prosecute, to restore competency, when what should occur is that the mental health issue is addressed. Another plus post SB 317. Whereas before, all of our FISTs were referred directly to our CONREP program for placement recommendations. The IST evaluators, the alienists, now are being asked to include within their reports to the court not only their finding regarding competency, but also a statement or two regarding the person's suitability for diversion. Now think about that. If the FIST evaluation comes to the court before the hearing, and the court looks at this and shares with obviously the PD and the district attorney this alienist findings that say, you know, this person is probably incompetent, but you know, they'd be an ideal fit for diversion. Well, now we've short-circuited the whole process. And so we're able to treat those folks within our DSH diversion program. One of the other things that we do currently is we work with DSH and their consulting psychologists to comb through the DSH wait list for our jails. So we have the Sheriff's Department has a jail-based competency program that takes overflow from DSH. DSH obviously is continuing to take felons. But there's still a wait list. And I think the last time I checked, it was about 60. So we work through that list to identify people who, by dint of their presentation, their risk evaluation, and so on, our in-reach team can then go back to the court and say, we think this defendant or that defendant might be appropriate for diversion. Put people in the right level of care. That's what that's about. So where do we want to be? Okay, well, right now we've got about 10 or 12 courts that handle diversion cases, which means that we have, just as we have 58 counties and 58 different superior courts, we have 58 different processes. We have 10 to 12 variations on a theme here within San Bernardino County. So working with the courts to establish a more standardized process is one of our goals. Two, we want to get rather more aggressive with our wait list reviews to make sure that we're not missing anyone. We've had a number of instances where folks are appropriate for diversion, but they are sent off to DSH or they're placed into jail-based competency program and so on and so forth. And then being able to identify potential diversion consumers is another one of our goals. So what gets in the way of all these things for us? Well, Katie, you mentioned it. Housing. The majority of housing options in San Bernardino County, as with so many other counties in the state, emergency shelter housing. Well, what about licensed board and cares, or what about social rehab units, or what about inpatient beds? Well, again, like so many other counties, we don't have as many as we would like. Staffing. If you've been on calls with me before, you've heard me say this, and I've heard you say it too. Staffing is difficult. It is difficult to compete for licensed clinicians or even pre-licensed clinicians with the likes of Kaiser or with other agencies. Plus, it takes a certain type of person to work within forensic services. It's very often the challenges that we face are very difficult. We deal with prejudices, we deal with procedural barriers, and so on and so forth. Other issues that we experience, as I mentioned, we've got inefficient or perhaps multiple workflows that are duplicative or working at cross purposes. And then there are geographical issues. Gold star to anyone who can say what the largest county in the United States is by geography? Anybody want to take a guess? If you're thinking to yourself, it must be San Bernardino, you're absolutely correct. So what I like to do is when I'm on these calls, I like to point that way. So if you drive about 2.5 hours that way, you come to one of my clinics. Well, I have folks that are in diversion that are spread throughout the county. And very often a very real barrier is getting on a van and driving 2.5 hours to program, spending all day in program, driving 2.5 hours back up the hill. We're not alone in this. Smaller counties up north, it may be a quick drive across the street, but having staff is a problem, right? So this is what I have for you today. Thank you again for the opportunity to talk with you.
That's great. Thank you to all of our presenters for providing your expertise and your perspective. We'll open it up to our council member advisors. Chief Jenkins, it looks like you're grabbing your mic. So.
Yes, thank you, Brenda. Thank you, all of the presenters. It's very useful information, and it's an ongoing education for me even as a council member. I don't have I'm not like Judge Manley, who has to deal with this every day, but I do have an interest, as just from a council's perspective, on frankly seeing how 317 rolls out. So I have a couple of questions. First one is for Laura Arnold, I think. Ms. Arnold, you mentioned when you were walking through, you made specific reference to Chief Heitman in San Bernardino County.
I did.
And who's a friend of mine.
She's wonderful.
She does a good job. But would you describe, I thought I heard you say something about probation would be doing supervised release, or talk a little bit more, or tell us a little bit more about what that role is going to be.
But before she and I ever met, she had been thinking about whether or not probation, which provides the pretrial supervision in San Bernardino or Santa Barbara County, whether there was some way that through the ability of so when a person is charged with a criminal offense, at the initial court hearing, the judge sets bail. And with one of the things the judge considers at the time of setting bail is an individual's criminal history, including history of failures to appear. So very often our unsheltered homeless clients have many times failed to appear for court because they don't have any idea what day it is. They don't have transportation, and it's far too conceptual for them to, quite frankly, even understand that it's an order. So they are not typically good candidates for release on their own recognizance. And that's why we see this population of unsheltered homeless, severely mentally ill, and substance abuse dependent individuals being held in jail on these very minor charges. It's not because anyone's assessed that they're dangerous. It's because no one has any confidence that they'll be able to come back to court. And so supervised OR, which is something that has been expanding statewide over the past 15 to 20 years and still growing in some places and growing and fully developed in others, allows for a level of reporting and supervision that wouldn't otherwise exist for a person who was simply released on their own recognizance and told to come back to court on a date. So with the addition of an embedded behavioral health worker in a public defender's office, particularly a public defender that does early representation and is involved, we believe that reentry begins at arrest. So the sooner we can start working with an individual who's been arrested, if we could work with them before they were arrested, that would be great, but it's not our point in service, right? So the sooner that we can start working with them, the better the outcomes are going to be for them. And to the extent we can partner with our county behavioral health with an embedded clinician who can help us at the very beginning with that motivational interviewing, with that client engagement, with identifying needs and supportive services, and even linking the client to housing, the sooner we can get them out of that cage, the sooner we can get them eating good food, the sooner we can get them sleeping okay, And the sooner we can begin to have conversations for them about a different way of maybe proceeding with their lives. And so because Santa Barbara County has a supervised OR program in place, it allows individuals who may be in the pre-cognitive stage of change, people who don't believe they have a mental illness, who do not believe that they need any treatment, and who just want to get out, and often for very good reasons. I mean, we see their pets being impounded and all sorts of things happening. So it's not, I don't judge the desire to get out. I completely understand that desire, but they might be willing to agree to consent to treatment as a condition of supervised own recognizance release, versus the reality, which is because of their history of failures to appear, because there's no housing available to them, because they're not receiving treatment, the judge doesn't feel safe or doesn't feel comfortable just releasing them OR. So this can happen as early as prior to arraignment. In most counties, pretrial services does at least a limited report for the court at that initial court hearing, providing them with some information about the individual, their criminal record, and their community ties. That there is a right to a hearing 5 days after that initial hearing for the court to reconsider its initial decision. That gives us 7 actual days without any time waivers or waivers of rights. That gives us 7 days from arrest to begin to work with a person and identify some services available for them in the community, but only if those services exist, and only if those services don't have what I'll call somewhat non-evidence-based charge exclusions, right? If we can just recognize that sick people are sick people, regardless of their present moment in time, then it opens the world to more possibilities. And so if we can give them that opportunity to live somewhere else, to get out of jail, to not be in a locked facility, or even if a locked facility is the appropriate placement, to agree to be in a locked facility. If we can give them that option and they get to make that one choice, that can be the first choice in a series of choices that get us to a point where they are not incompetent to stand trial when the evaluator comes to see them, and where they actually want to continue with their diversion program because they're feeling better, because they're sleeping better, because they're clean, because they're getting dental care, because they're getting proper nutrition, and because we're working to reconnect them with their families, or we're giving them those concrete rewards like coffee or a pizza night, or I'm going to use someone else. I'm going to actually quote Kathy Hickenbottom, apple juice and cookies and graham crackers, right? This is right. Everything is immediate. Everything is right now, and everything is immediate gratification. And so getting out of jail, I tell you, after 30 years of doing this work, is the #1 priority for literally every client that I have, particularly those who are severely mentally ill and those who are duly diagnosed. So that's the idea, that's the concept. And that if we can do that up front, we don't wind up going the involuntary treatment route with those abbreviated timeframes.
Thank you. I appreciate that. That sounds like quite a bit of engagement at the supervised OR stage, and that's what you're describing, right?
It's a
So
very small. It's a very small population we're talking
Okay.
about here, right?
Okay.
So at least in Santa Barbara County and Los Angeles County, it's a humongous population.
Sure.
And so, I'm kind of referring to a mid-size or small-size county, not that this would necessarily, I mean, on a large scale, this would be amazing in a large county.
No, I
But-
get that.
Okay.
But can you give some examples of some ordered conditions, or are the conditions even ordered on supervised OR?
So we're still at the implementation stage of this idea, and we meet regularly as we continue to build it under the leadership of the CEO. But some concrete conditions of supervised OR is that you not use or possess any controlled substances without a prescription, and you submit to drug testing when asked by your supervised OR officer. GPS can be used as a tool of supervised OR, which allows placement in an unlocked facility of somebody who would potentially walk away if they weren't subject to GPS. Consent to treatment as prescribed by your doctor and with the understanding that your public defender will advocate for you should there be any problems, should you need help with getting the treatment that you need. And I think that going back to all the conversations about peer navigators, I think that knowing that there's someone there who they can just talk to when they don't feel like they're being heard, even though maybe they are being heard, they don't feel like they're being heard. And we listen for a living. So if there's someone there that they can talk to when they don't feel like they're being heard, who's their case manager or their peer navigator or their public defender, who has a manageable caseload and the time to take their call, that is absolutely going to increase the likelihood that they're going to continue with treatment and feel supported and feel protected, as opposed to feel like they're having something jammed down their throat that they don't want.
Have you started tracking any outcomes on just the supervised OR?
We have not yet because we're still at the implementation stage.
Okay. Anne, last question for you. In 30 years of doing this work, at what point did you learn the stages of change? I'm impressed that the public defender knows the stages of change. I was just curious.
Well,
at
I
what
was
point
trying
did...
to implement.
I
I was trying to
impressed.
implement mental health diversion in Stanislaus County, and so that got me involved in a conversation with the public guardian here, who took me on tours of all sorts of different facilities, different levels of care. I had actually already toured the jail-based competency treatment programs in San Diego and San Bernardino counties, but I hadn't seen what a residential facility looked like. I hadn't seen what an IMD looked like. I hadn't really been in a board and care. And it was incredible. And I learned so much that most public defenders probably don't get to learn. And that just comes from looking around and seeing what the signage is and what the events are and how the people are treated and what the food is like, and comparing that to how my clients, same people, are treated when they're in a cage. And I found that to be incredibly powerful. And that's when I realized that incentivization is everything with these folks, and that there is no deterrence, there is no stick. They don't understand you'll go back to jail if, or you'll get your charges dismissed if. Just like, when I want my daughter to do her homework or clean her room, the promise of Jamba Juice is going to go a lot farther than the threat of missing gymnastics tomorrow. So, or whatever conceptual thing I want to come up with, it's the right now. And so I watched it work, and I realized that the criminal justice system is not doing it the right way.
So it wasn't something you learned in the beginning, but something you picked up along the way, is what I can take from.
Something they do not teach that in law school.
Okay. All right. Thank you. And now I have a question, Katie. In what you covered, you made on your slide where you have CCJBH and DSH diversion project activities, you mentioned that you also met with judges.
Mm-hmm.
What did the judges say?
Yeah, I mean, that's a great question. And Judge Manley was there. He was, helping us facilitate that conversation. So he's welcome to join in too. But, we didn't talk specifically about SB 317 in that session. We talked a lot about, along these same lines, like how judges can help motivate participants in diversion, kind of like basics of motivational interviewing, sanctions and rewards, like Laura was just talking about, that a judge can use. We talked a lot about, how, and this was mentioned earlier too, recovery is not a linear process, and that treatment plans and treatment needs to be flexible. What else did we talk about? We talked a bit, and this isn't really related to this, but about, how judges can work with the victims, if there's victims involved in cases where diversion is being considered. It was a really great discussion. We talked a bit about and we talked about this a lot throughout the learning community, like what's eligibility versus suitability for diversion. Someone can be eligible for diversion because they have a diagnosis that's in the DSM, but does that mean they're suitable for the treatment options that exist in that county, and kind of those nuances and challenges. I'd welcome Judge Manley to add anything that I may be forgetting, but it was a really great discussion. Again, we had such a good kind of mix of judges from small counties, bigger counties, mid-sized counties, that it was an interesting discussion.
Judge, anything you would add?
All right. No, I think the only thing I would add is that judges are struggling with diversion. And I think it's, to be expected. It's a new program, something they're not used to. There's some pending legislation that may clarify a number of issues, but I think I think one of the things that happens is you make it too complicated. Eligibility and suitability, and you use these words, and to me, it's straightforward. There are 5 things you got to cover. You go through those, and that's it. And the legislature is considering a bill to shift the burden from the defense to the prosecution relating to whether or not the mental illness played a significant part in the commission of the crime. So, which is I think a challenge for many judges, and also the public safety concerns, because the definition of dangerousness is basically super strikes. And yet the statute has a great deal of language about looking at criminal histories, listening to the district attorney. So it's somewhat confusing, but the appellate courts have made it very clear. What I know was the intent. I don't really absolutely know, but they feel was clearly the intent of the legislature that only super strikes would. The possibility of committing a super strike would disqualify someone. But I think it's challenging. But I think, as Deanna said, as time has gone by, we've seen more and more diversion taking place, and I think that's with judges getting more comfortable with the process and making decisions within their own court, as to whether or not they're going to do it through one centralized place with judge or group of judges, depending on how large the county is, or they're just going to leave it up to each and every judge hearing criminal cases to make the determination. And of course, the issue of monitoring. Are you going to follow the individual, or are you just going to have them come back in 6 months and make a determination of whether or not they've successfully completed, or you're going to hold a hearing to find that they have failed the program? So I think, it's a work in progress, and I think we just need to be patient. I think the concerns of judges are the concerns they always have about, change is difficult for judges. I know it's difficult for me. It's difficult for anyone to adjust to. So I think you have to be patient and wait.
Thank you, Judge Manley, and thank you, Katie, because I think it's that important for the reasons that the judge just talked about. And actually, I was candidly pleased to hear some of the topics that you said did come up in that conversation, because you talked about how to motivate the folks that they're appearing in front of them, talking about motivational interviewing and sanctions and incentives, et cetera, things along those lines. So I'm going to shift to Deanna now and just ask Deanna if those topics are they being touched on at all in the work or your conversations at the Judicial Council in terms of the judges' roles?
Yeah. I'll say I'm going to set myself up for success this time and take off the mask before I start talking. I would say absolutely. I would say one of the considerations in, just looking at diversion and some of the themes that Katie touched on is within the realm of SB 317, the people who are going through diversion through that route cannot necessarily benefit from diversion programs that are funded by DSH. So there is the question of resources and availability. As courts are looking to move people into diversion, if there is funding for, certain people, if it's not expanded to everybody who could benefit from it, there's going to be some things that are left behind. So, just being mindful of that. I would say another thing that courts are also looking at, and this may be particularly courts that are in smaller jurisdictions where there may be more limited services available, is looking at the availability of services, if the services are accessible. And Mr. Ogilvy, he mentioned that there may be a center that's 2 hours away. So looking at if the person's going to be released to diversion, will they be able to access those services? And then also looking at responsiveness and, are these services actually going to respond to the need of the person? Is it going to be something that's going to allow them to get what they need to be the most successful? I would say a lot of also what I've heard is, the courts are really looking at procedural justice. So how can they implement everything in a way that is not necessarily setting people up for, continued court hearings that may not have come into play otherwise, but because they are being, they're being put into the different programs that are available, whether it's diversion or, AOT or conservatorship under 317, if they're making it the best possible experience for the person and for all the stakeholders who are involved, who are working with the person, as well as for the person themselves. So I know that answered a little bit more than your question, but if there's any follow-up.
No, that's very helpful. Thank you too. Thank you to both of you. Thank you to all of you, but I don't have any other questions.
Ms. Arnold, I wanted to ask you, since you were involved very directly in the drafting of the legislation, now that it is on the books, do you have any suggestions for any changes, modifications to the statute?
I do.
That you would feel would help us do a better job in implementing it?
I do in terms of the mental health diversion statute. I think that there's a pretty significant flaw in that statute that is creating a real barrier for judges who do want to have full-blown hearings and make the right decision about diversion. May I speak to that, Your Honor?
Yeah, absolutely.
Okay. So AB 1810 was enacted as a trailer bill, and in that version of the statute, there 1001.36, there was no screening out provision. The court, when anyone who filed a petition for diversion was entitled to a full-blown hearing, and that statute was amended by Senate Bill 215, which was responsive to a lot of outcry on behalf of law enforcement and a little bit of outcry on behalf of superior courts that everyone in the world would be applying for diversion, and that if the courts were consumed with such a quantity of hearings, they wouldn't be able to actually make the right decisions and do the right thing within a reasonable amount of time for those who were truly came within the spirit of the diversion statute. And so with SB 215, with the amendments that were made to 1001.36 in late summer of 2018, there was a little catch-all that was a little subdivision that was put in the statute that allows for the court to ask for a prima facie showing from the defendant, from defense counsel, before ordering a full-blown hearing. And it looked like a great idea, and it was a great idea. But the problem is that in that prima facie showing, which is a very low threshold based on recent decision by our Supreme Court, it went far beyond information that the defense counsel could really present. It went beyond showing that the defendant has a mental illness, that the mental illness can be treated, period, that the symptoms of the mental illness were such and such, and they contributed in such and such way to the commission of the charged offense. They require the defendant today to prove that if the defendant receives treatment in the community, he or she will not pose a unreasonable risk to public safety. So in other words, to prove this negative at this prima facie stage before there's even been a hearing set. And the problem with that is that it makes it really difficult for behavioral health departments to figure out where to put their resources. Because if no one can decide the safety question until we know the treatment plan, until we have an assessment of the individual's treatment needs, and until the appropriate level of care has been determined. And so to ask a judge at the prima facie stage to find that if treated in the community with whatever amorphous program we might exists out there, but which we haven't yet told you about, there won't be a danger to public safety. One, it's requiring us to prove a negative, and it's impossible. And two, it makes it impossible for us, very, very difficult for us to overcome the hurdle at that stage and get to a full hearing where, to a certain degree, the rules of evidence apply, and where experts and those who are trained at assessing treatment needs and creating and implementing treatment plans can explain to the judge why, in this particular case, a program of diversion and mental health treatment with an appropriate level of care is actually better for public safety than a 16-month state prison sentence, followed by post-release community supervision, or whatever the alternative may be. And it wasn't until really digging in Santa Barbara County and seeing how the courts here are looking at that prima facie showing and hearing from people around the state that I realized that as much as it's difficult to explain to judges that stimulant use disorder is actually in the DSM-5 and that it is in fact a mental illness, it's much harder to explain to judges why a person who's actually receiving treatment with wraparound services and case management is less likely to resume criminal behavior that are really stem from symptoms of untreated mental disorder than a person who's simply on probation. And no disrespect to probation departments, but if that had been working, we wouldn't be in this crisis. So we have to just completely stop thinking about criminal justice and consequences for behavior and addicts being bad, but mentally disordered individuals without co-occurring substance abuse disorders being less bad, and stop thinking about everything in terms of black and white and start really just trying to understand the whole person. So,
Okay.
is that what you wanted, Judge Manley?
No, it's very, very helpful. Let me follow up with this. I think it would be very helpful for your view or anyone else's. I think one of the because I've worked with misdemeanor IST individuals for years, and many of them do not feel they're mentally ill. They want a trial. They don't want to go through this nonsense because they didn't do anything. It was the other person or whatever. And then the issue comes up. Well, they don't want treatment. They don't want to consent to it. They don't want to even be considered for it. They just want, and they don't even want the charges dismissed because they want to prove their innocence. And I hear this nearly every day from individuals, and I fully understand where they're coming from, being where they are. But my question is, do you really think that we should be concentrating on these not traditional, but these statutory schemes that we have, diversion, 1810, AOT, and now, of course, this bill's pending the care court. That would be another alternative. Or should we or should we just look at this as something, to me, the issue is we need to get people into treatment. We don't need to have all these blocks on, that each program has different criteria. And I know the way, at least the way I read SB 317, once the judge makes a referral to AOT, the judge dismisses the case. Once the judge refers to the public guardian, the judge dismisses the case, which doesn't necessarily lead me to believe that people are going to get the treatment they really need. And if we really care about that, we ought to focus on it. And so it just seems to me that if it might be a better system if we could just refer people to treatment and let it go at that, instead of trying to meet all these other criteria, these other programs, and never know what happens. I just suggest that. I mean, in what I have done, since I have all the misdemeanor ISTs as well as the felons who are diverted, and we diverted large, I think over half that we have, I have found we have stopped this process of having all these alienist evaluations, and it takes so much time to get anything done. Even in a large county like mine, it probably takes longer because we cannot pay experts. And so what we do is we bypass all of that, and if the minute the doubt is declared, they are referred directly to me, and we try to place them in treatment, try to get them to start their medications if that's an issue, but we cut through the time issue. And the reason I wanted to ask you, well, Dr. Oglesby or, well, any one of you, is there, when I see that in discussing this with the judges, there's an issue about they want more time. And to me, that is what's been wrong. We warehouse people for years and never do anything. It just seems to me that we should shorten the time, as San Bernardino's doing, and as the care court bill calls for, these 14 days, 5 days. I think that really makes far more sense than having it longer. And I think that we should change our expectations. We're not going to restore anyone to competency in 6 months. I mean, we aren't. We're just not going to do it. And you take all the violations of parole, violations of probation, violations of PRCS. If the individual is incompetent, how much time? You have exactly 6 months. That's all you have. You don't even have a year. You have 6 months, and that's it. And so nothing ever happens with those individuals. And I just think we really need to sit down and think this through and come up with a different way of doing things. I mean, for example, Dr. Oglesby, you talked about San Bernardino. You don't even, the lower level, the nuisance offenses, do they really need to even be in the court? And as was pointed out, I think doing something ahead of time. I would like to know what you would suggest. We try very hard, and I'm a great advocate of let's intervene before they even get to the court. But I don't see that happening. And I have a theory that you should, or a proposal that what one ought to do is to intervene prior to booking, to stop the process there and divert, and then see what happens. But I would like your thoughts on that, because this is, to me, one of the most difficult issues for judges is judges don't want to dismiss cases just to dismiss them and be backed into the corner, particularly judges I know who are in relatively smaller counties. They have to run for office. You never know what will happen. And if I realize, it may be domestic violence, it may be something else, battery, an offense involving violence, that's a misdemeanor. the judge is not going to want to dismiss automatically. But I think if we frame this all differently, the whole system, it would be much easier to work with these individuals who are so challenged. So I'd appreciate anyone's feedback on that issue. Number of issues.
Well, I can, if you'll allow me, I have a unique perspective in that I've spent, let's see, about 12 years working in state prisons. I think I've worked in about 12 state prisons across the United States. And the numbers of folks that are incarcerated who present with extraordinary mental illness is only rising. In California and CDCR, that percentage, if you will, is rising because of legislation that requires offenses to be treated to not be eligible for state prison or for early release. We have Coleman v. Newsom v. Brown v. Reagan v. everybody to thank in part to that. So something needs fixing. Because the state prisons nationwide, the jails nationwide are simply becoming state hospitals. So I agree with you 104%. I want to echo back to what Henry said. It is the rare presentation, mental health presentation that occurs late in life. Now, there are some that will, trauma, for instance. Substance use disorders can strike anyone at any time. But we typically see the expression of significant mental illness earlier in life. So when we think about investment in the community, not necessarily in criminal justice per se, but in the community overall, whether it's raise awareness, provide greater resources, more mental health resources in schools and in the community, to me, these are just common sense ideas. If we are assuming that diversion is predicated on a nexus between a mental health issue and the commission of a crime, well, if you get rid of or you successfully address the mental health issue, well, guess what? You don't have the crime. Some everyday things that we can do now, we're working with our sheriff's department to begin to think about ways of identifying folks who are frequently arrested, particularly for these quality of life crimes, homelessness, public intoxication, and so on. And as you probably are well aware, we have a small pocket of groups that get arrested a lot, 50, 60, 70, 100, 200 times. Well, if they are being arrested for the commission of crimes by dint of their mental illness, again, if we find a way to address the mental illness, we won't have the rearrests. Now, what keeps us from doing this? Can somebody loan me $20? It's money. I think it's probably safe to say that with relatively few with the exception of a few counties, most county departments of behavioral health are understaffed. It's difficult to compete. So right off the bat, the prime mechanism for providing those services as a mental health plan to the types of people who tend to get arrested, already short-staffed, already under-resourced. So working collaboratively with your sheriff's department, with your probation department, with your, we have a criminal justice consensus committee with the chief judge, with the public guardian, with the sheriff, with the chief of probation, managed care plans. These are great opportunities. Again, I think back to the learning collaborative that Katie hosted the last 6 weeks or so. Being able to identify gold standard interventions that can be implemented at ideally low cost. That's a great place to start.
Thank you.
Great. And I was actually just going to say, I'd be remiss if I didn't point out, you know, a lot of what Ms. Arnold was talking about earlier and the needs of this population, and even Dr. Oglesby just mentioned it, was the role of the managed care plans, the Medi-Cal managed care plans in California, especially under CalAIM, with the new enhanced care management benefit, with, you know, people with serious mental illness being a population of focus. And so in the communities, you know, as of July 1, like right now, as of January 1, the whole person care counties, you know, would still serve the, you know, population of focus of serious mentally ill individuals, could do an enhanced care management assessment on them and put them down that path of that enhanced care that they could receive. And then as of July 1, the rest of the Medi-Cal managed care plans will be required to come online. So, you know, it just had me thinking while you guys were talking of what those opportunities are like now and July 1 in terms of enhanced care management and the benefit of it and the community supports that many of the Medi-Cal managed care plans have opted into, and how that might connect in with the court processes or, you know, these individuals with who are falling under SB 317, because basically they're on the radar at that point. So they're a known population. So how do you connect them up and get them that referral to their managed care plan so they can get an enhanced care management assessment, potentially get connected up with an enhanced care manager who could then, you know, coordinate all their care across the Medi-Cal delivery systems, being primary care, both mental health and substance use and dental, and be able to, for those community supports that those particular managed care plans opted into, also be able to connect them with those services as well. And so right now, like I said, at this point in time, it would be for those who are living in the community. So if they're in jail, that couldn't apply because you can't do that kind of service in jail until and unless the 90-day in-reach is approved by the Centers for Medicare and Medicaid Services, and DHCS is still working on negotiating that with the federal government, and that's still slated to come on board in 2023. But just trying to think about even now what could be done with especially the SB 317 population, and getting them connected to getting referrals to their managed care plans, getting them enrolled into a managed care plan, and then assessed by that managed care plan for enhanced care management.
You know, if I could jump in real quick.
Yeah,
Michelle,
please do.
got your hand raised. You know, I think about legislation like the proposed care court legislation, which really puts the finger on county departments of behavioral health to be the prime mover and shaker. Even if any given person who would fall under the auspices of the care court, even if they receive their services from a managed care plan. So I think from a broader political viewpoint, if we can find a way to make it easy for the managed care plans to come in and serve in the same way that county departments of behavioral health do, I think that would go a long way towards that.
Yep, and that enhanced care manager, that would be one of the responsibilities is to coordinate that care with county behavioral health, in addition to all of the rest of the delivery systems and the community supports, which hopefully would take a little bit off of county behavioral health, so that county behavioral health is only focused on the behavioral health needs of that individual. So thanks for the for adding that additional information. So it looks like I think our council members have asked their questions, and we've got about 12 minutes left. So let's move to public comment. It looks like we have Michelle Funes Aretaga. I'm sorry if I butchered your name. My apologies.
No, that's okay.
Please.
So I'm a social worker, and I work in our county's forensic division, including overseeing jail mental health and
Uh-oh, it
diversion.
looks like you're a little...
Having trouble hearing you.
Yeah, sorry, Michelle. It's coming out a little garbly.
It is.
Oh, that
That's
sounded
better.
good. That sounded good.
Okay, let me know if it gets garbled again.
Oh, it is
It's
still
garbled
sound.
again.
Yeah.
Let's see, can you hear me now?
Yes.
Is this any better? Okay.
Fantastic.
Perfect. Don't
Usually
move.
works. Maybe it's fine. So I was saying I'm a social worker. I work in our county's forensic division, including overseeing jail mental health and diversion. I've been doing this work with this behavioral health population for probably 25 years in jails and prisons, the community, the veteran, pretty much everywhere. I used to say that, in working in jails and prisons, we end up serving some of these seriously mentally ill folks in these environments because the criminal justice system was the only system that couldn't say the services couldn't be declined, right? Coming to jail wasn't like, no, thank you, not today. And you didn't have to meet criteria to get in. I mean, you did have to meet some criteria. You had to be alleged to have committed a crime, but we couldn't say, sorry, you don't meet our admission criteria. Sorry, we're our jail's full today. No coming in for you. And so the criminal justice system became, and for a long time, and still is oftentimes, it's the catch right at the end for people who are at least who are behaviorally dysregulated. The concern I have, and I think some people touched on this, Judge Manley touched on it, and Dr. Olsby's touched on it, is that it feels to me like we're missing a piece, and the piece we're missing is involuntary treatment. For the people that are seriously mentally ill, who have no insight, who think we're poisoning them or trying to murder them, or those sorts of things, apple juice, cookies, housing, getting out of jail, none of those things are incentives to participate in treatment. And so there's no amount of rapport building that we can do, no amount of conversation. We watch these people decline in our jail for months and months and months while they wait for a DSH bed. I know we're talking about misdemeanors, but still that demonstrates it because we try over those 6 months while they're waiting to go, everything we can. Felony mental health diversion, we'll get you out, we'll get you housed, we'll get you that. No, none of it because of the mental illness. So, on misdemeanor IST, the diversion piece, the lawyers have to be ethical and tell their clients, look, here's what's going to happen if you accept, and if you don't accept diversion, charges are going to be dropped. I won't get into why AOT doesn't really serve this population. It's complicated and layered. We don't have those, we won't work with you if you have certain charges, things that Laura was talking about. Fortunately, that's not a thing in our county other than 290. That's always an issue. But other than that, we don't really have those challenges. But AOT I've not seen it be a great fit. I won't get into that. That's a longer conversation. If someone's gravely disabled, we get them out right away. We get them hospitalized right away. If they're misdemeanor and they're gravely disabled, we're getting them out and into treatment. So conservatorship's not really a thing here either, because you have to be gravely disabled to start that conversation. So what we're left with is what SB 317, in my opinion, does not address are these people that are the most severely mentally ill, the most acute, with no insight. Usually there are behavioral problems. They're breaking windows in the community. They're stealing. They're, threatening people. They're doing something to get arrested. And it's very sad. With the old model, and I know there were a lot of problems with it, but at least we had an involuntary treatment option in the old misdemeanor IST model. And that's gone. So I feel myself going, well, we just lost a tool for some of these people that just don't really fit anywhere else. And now we're left with just letting them out in the community and waiting for a felony, frankly, so that they can go to DSH. We could get into what's wrong with all the other parts of our system. In our case, in our county, I really don't think it's a lack of outpatient treatment options. It's not really a lack of, resources that this niche group of people are why they're falling through the cracks. It's because the illness includes anosognosia, includes this inability to see that you have a problem. So I'm just making this comment that we need an involuntary treatment option desperately for these folks. And until we get more of that, there's these people that are the most ill are going to continue to slip through the cracks.
Thank you for your comments. Okay. Is there anyone else that wants to make a comment from our public participants?
No one? Well,
No one?
well, let's continue then.
All right. Well, I do want to say a big thank you to all of our presenters today. This was just a great, robust conversation, and it's a very complex issue. And there's so much happening right now in terms of investments in our states and just trying to, support these populations to be able to live in our communities and live happy and healthy lives. And so I appreciate all of you working so hard on all of this and taking your time to share your subject matter expertise with us. So I think if we could just get the PowerPoint back up again, we just have a couple little announcements to make before we adjourn on this Friday afternoon. Our upcoming events. So we just held our juvenile justice and diversion and reentry work group meetings today. So this is our first time putting them both on the same day in some time. And we are going to plan to do the same thing in July. So Friday, July 15th. Again, here at the Board of Parole hearings, juvenile justice work group meeting from 12:45 to 2:45 again, and then the diversion and reentry work group meeting from which should be 3 o'clock to 5 o'clock. Looks like there's a little typo there. And then the CCJBH full council meeting will be on Friday, July 29th from 2 to 4:30. At this point, we have it scheduled at our Elk Grove location again, but we will wait and see if we end up confirming that. As always, we have our website, our CCJBH website presented on this slide, and our email address again. And we also have our listserv, our CCJBH listserv. We send out Friday partner news and events with all the latest and greatest that we're aware of happening either with our own projects or with our partner projects. And that's across multiple systems that serve our population as well as across the age span. And I just will do a shameless plug as well for our May is Mental Health Awareness Month. So as you see, I'm wearing our lime green today. So this is May is Mental Health Awareness Month. We've been hosting lunch and learns each Wednesday of the month, or each Wednesday of the week throughout the month. We will be hosting next Wednesday a lunch and learn webinar featuring the Los Angeles Regional Reentry Partnership, or one of our lived experience contractors. And then the following week, we're actually going to have to do it on a Friday. We're going to have the California Department of Public Health talking about their Community Mental Health Equity Project. And that is because there's a big event at the Capitol for May's Mental Health Awareness on Wednesday, I believe it's the 25th, May 25th. So with that, thank you all for being here today, for coming in person, for joining us via the video conference. A big shout out to the CCJBH staff who are pulling all the strings behind, it's a lot to coordinate all of this. So thank you all for all your efforts. And thank you again to our panelists again for taking the time out of your day to spend time with us to have this discussion. All right, with that, we will go ahead and adjourn. Have a great weekend, everybody. See you next time.